Welcome back, Honorable Commissioners. Welcome, Judge Marete, to this interview. I think there'll be a session of photographs, and then we'll start the session, Your Honor. So please, 1 minute for the photographers. Thank you very much, Your Honor. Once again, welcome to this session. This session, Your Honor, will be a bit shorter because we had a long discussion with you about 2 weeks ago. And the commissioners will determine what to focus on, maybe more on the jurisprudence and other legal matters. We will introduce ourselves once again to you, Your Honor, and I will start with our acting CJ. The technical people, we need the microphones to work. AG, is yours working? We can start from your side. And then we'll come round as they fix that one. Frida.
Thank you, Madam Chair. Good morning, Judge. Kehara Kariuki, the Attorney General.
Morning, my Lord.
Morning, sir.
Mohammed Morsame, welcome once again, my Lord.
It's a big pleasure all the time.
Good morning, Judge.
Morning, sir.
My name is Felix Koske, representing the public. Welcome.
We thank you.
Good morning, my Lord. My name is Machari Njero. I represent the Law Society of Kenya.
It's a big pleasure, good Commissioner.
Good morning, my Lord.
Good morning.
I am still Philomena Mbeteni. I represent the Supreme Court here. I'm the Deputy Chief Justice of the Republic of Kenya.
We thank you.
Good morning, Judge.
Good morning, sir.
I'm Patrick Shoi. I represent public service. Karibu.
Asante.
Good morning. David Majanja, Judge of the High Court, representing Kenya Magistrates and Judges Association.
A big pleasure, sir.
Good morning, my Lord.
Good morning.
I'm Olwande Evelyn, Chief Magistrate representing KMJ.
We thank you.
My Lord, I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. And we also are supported by our CRJ, Honorable Anne Amadi.
Good
morning, Judge.
Good morning.
And also by the Registrar of Judiciary of JSC, Honorable Frida Mukaya.
A big pleasure to you all.
So, Judge, will start with the interviews now, but I have one observation to make. The fact that you have received the letter where you have submitted the documents that were missing last time. The web declaration, now you have completed it, and the bank statement. Your Honor, I also noted that we have now a new copy of the disability card, which, as you said, it was an error and it has been corrected. So I just wanted to make that observation, and I don't know whether you have the original or we go by this copy.
I do have the original. It is available with me.
Thank you very much, Judge. So those forms are now with us, and we want to thank you for that effort.
Thank you.
So I'll start off by asking one question, Honorable Judge. If you join the Supreme Court, where there will be other colleagues, working with you, and so far, Your Honor, you have been your own boss, making your own decisions and have, enjoying your independence. So please give us 3 differentiating attributes that you are going to take to that court. Because we all have our own strengths. What is this that is unique, Honorable Judge, that you are going to take to that Supreme Court?
To the Supreme Court, I'll bring in collegiality in a personal manner. I am a peacemaker. I am able to deal with public relations so finely. I make peace with everybody and anybody. That is what I would take to the Supreme Court firstly, to enhance collegiality, to enhance team spirit, to enhance what we may require in the Supreme Court to be able to be effective and play our role, our constitutional role as stipulated. The second one, which I would take there, is my exposure and experience from day one and 16th of October 1980 to date, well over 40 years. We've been in this game, the game of the law, and we've learned the ropes. So you will not be able to say that, or we cannot say that because you've been your own boss, etc., you are not superb or fit for this kind of a position. When you have the know-how, when you have the exposure, we've been to the House of Lords, we've been everywhere in the common law and the Commonwealth. We've been in Kenya, we've done East Africa. We are familiar with this game, and there's nothing which would make us any poorer in dealing with the issue. We also have our own good attributes. Like I said last time, I'm a superb leader. It is demonstrated all over my life. I gave, notable examples of my leadership capacity. I've not been working alone, and it is not possible to work alone. So this is what we would carry to the Supreme Court to enhance its efficacy in constitutionalizing constitutionalism. Thank you.
Thank you, Judge, for that answer. Your Honor, there's some theories that suggest that for you to get to achieve your deliverables or your goals, that you need maybe 70-80% emotional intelligence and maybe 30%, 20% of IQ. Do you believe in this view?
So much so. It is the rule of the world. It is a universal truism that so much is not done on by virtue of your strength or intelligence. Those are just side issues. What you require is the element of a relationship that carries the better part of your projections, the better part of your achievements, etc. We are saying this because you may have everything that you may require in terms of IQ, etc. But this is not going to work for you if you don't have the wherewithal of, emotional intelligence, if you cannot relate, if you cannot be able to differentiate what is workable and what is not workable, if you are not able to deal with everybody with a view to achieving any collective results, that way your brain, your intellectuality, your all becomes not very useful to humankind. Therefore, this is a daily practice, something you must keep on learning to do every day of your life so that you become useful. Minus that, you'll be on your own and you won't make any contribution whatsoever to anybody. Thank you.
Thank you, Your Honor. My next question, Your Honor, is in every group, even in the Supreme Court where you go, there will be the leader. I mean, your leader will be the president of the Supreme Court. But also in all the groups, there emerges other leaders who are not there because, by virtue of their positions, but they're just natural leaders in that group. So my question to you, Judge, is that do you see yourselves emerging as another leader, maybe in an area where you're very strong in, or are you just going to, to follow what your boss says? And if you're going to emerge as another leader, which area do you think you can come out strongly as a leader, despite the fact that you'll be having your president in the same court?
Thank you, Chair. I'll clearly and undoubtedly emerge as a leader because this has been demonstrated. Organizational skills is my hallmark. Last time we were here, I told you that I'm a very organized person. I am a very timeous person. I get things done and on the dot. This may be boring to many other people. You don't necessarily have to get them into it by force, but you can buy them into it. You can teach them the game. So organizational skills, industry are my hallmarks. And this is demonstrated all over from day 1 to 61 years and 4 months. That is what I'm going to sell to the Supreme Court of Kenya. I'm not confrontational. We shall have our natural leader, the President of the Supreme Court of Kenya, the Deputy President of the Supreme Court of Kenya, and the other group of 7, and it is proposed 9, maybe in the future, will come up with a different leadership quotients and serve the court, and serve Kenya, and serve humankind. Thank you.
Thank you very much, Your Honor. I will now request Acting CJ to continue with the questions.
Thank you. My Lord, let us start at the point of amicus curiae and interested parties. If my Lord would please tell us how the court, my Lord, wishes to join, has handled those 2 issues.
Traditionally, good acting CJ and Commissioner, amicus curiae was a friend of the court. That is a customary position. This has developed with time, and it has even gotten very complex in the sense that we have had to develop other avenues in which to accommodate amicus curiae. In interested party, the differential between amicus curiae and the interested party is that the interested party has a direct interest in the matter which is being heard. Let me go back to amicus curiae. What has changed of late is that we found the situations, and we will be forced to address these situations in the future, where people do not necessarily come to courts as amicus curiae to pursue that unilateral, that area where they are just friends of the court and impartial. We've noted More often than not, that these people may come on that note, but in the course of time, they become even parties to the suit. So we may have to, in the future, develop strategies. So we're dealing with that because where, like is in the international foreign practice, we even have amicus curiae who may have some interest in the matter. Amicus curiae who may not, who clearly do not have any interest in the matter. The categorization of amicus curiae must now be developed in this in our jurisdiction, so that we are able to manage that in an effective manner without hiding faces or playing behind. Interested?
No. Let's stay with the amicus curiae first.
Yes.
And the question, my lord, is to tell us what the court, what your dream court has already done, because it has, in a number of cases, defined the status of the amicus curiae and how one is to approach the court.
The court has set out precedent to the extent which amicus curiae would come out. This is by bringing a 6-point amicus curiae forum. And this is what I was referring to, like moving from the traditional amicus curiae where you are merely a friend of the court. We brought out issues where people who have some interest of whatever nature may come in as amicus curiae. We brought in areas where people who have no interest whatsoever may come in as amicus curiae. We brought up other issues where we brought in a situation where other parties who have tangible issues on that subject matter may want to come in as amicus curiae. We may have other situations where groups or interested parties may want to come in as not as individuals but as a group to raise issues which add on to the subject matter and assist in its formulation. Those are the few examples I can remember.
Okay.
There are quite a number.
Okay. Does my lord remember any Supreme Court case that has specifically dealt with the amicus curiae?
I have read this generally. I cannot specifically
Thank
point
you, my
out
lord.
any authority.
Is there a distinction between, my lord, the amicus curiae and interested party?
The distinction is very, very clear. In interested party, this person has a direct or even indirect interest in the matter. The outcome of the matter will directly involve him, or directly or indirectly involve him. So he is not coming in, he's not even borrowing from the traditional amicus curiae where you are a friend of the court. He is coming in to pursue his interests, which may be direct or indirect. That is the difference.
Any case that comes to mind, my lord, by the Supreme Court on...
Again, on that one, I falter.
Thank you, my lord.
Please.
You would say, or would you not, that the Supreme Court is not busy, would you?
No, the Supreme Court is very, very busy. Very busy to the extent that it is even backlogged, which is very, very unfortunate. That's a place, if you ask me, where we should be free of a backlog. And they'll be dealing with matters within a month, 2 or 3, when that is practical and possible. The Supreme Court is busy to answer your question.
Do you know, my lord, the extent of that so-called backlog?
It is about 200 and, did I read 235 cases? It's between 100 and 250 cases, if I read right.
My lord, that are backlog in the Supreme Court? Let's stay there. And please, my lord, tell us what in
that
your
could be
view...
the number of due cases. Please ask your question.
I already asked part 1, but let me ask part 2. Whatever the backlog could be, Might my Lord know the reasons leading to that backlog?
Yes. One is incapacity. One of the biggest issues we have in the Supreme Court is incapacity. There are 7 judges. Of these 7 judges, one is the Chief Justice, the other one is the Deputy Chief Justice. At all times, one of the judges would have to appear in the JESC, or Judicial Service Commission, as a representative of the Supreme Court. We have issues of incapacity. People, the judges, one of the judges may not be available for 1 or 2 reasons. Ailment, being away for good measure. So, one of the basic reasons why we have, this backlog is because of the issue of the quorum for the Supreme Court. The quorum is 5 judges in open matters. The quorum is 2 judges in interlocutory matters, applications. So the possibility of not having a quorum in this situation is very, very high. For example, now the Supreme Court does not have two judges, the Chief Justice and the Judge of the Supreme Court. They are not available. Should anything happen to any of the other judges, it will not be possible to convene a quorum. Should, in a situation like this one, where her leadership is appearing at the JESC for this very, very important matter, the Supreme Court cannot sit, and that is the dilemma.
And therefore, my Lord, clearly you have read our strategic plan. You have seen that we have identified that as a big problem. What would your remedies be?
The suggested remedy in the strategic plan is that the Supreme Court be raised constitutionally to 9 judges. I had all my life wanted to fight that. But recently when I looked at that and the rationalization of the strategic plan for the Supreme Court, it brought me to senses. It makes a lot of sense. The situation we have now is impractical, if not impossible. It's a do or die situation. This is a very, very, very sensible, proposal that the Supreme Court firstly be improved by 2 other members or 2 other judges, and maybe in the future we can even move up to 11, depending on the constituency.
Thank you, my Lord. One of the objectives for the court is to provide authoritative and impartial interpretation of the Constitution. You have also, my Lord, heard, and please tell us where you heard it, this statement, constitutions without constitutionalism. With that in mind, would my Lord debate the particular objective of the court that I have just stated, my Lord?
Thank you. Constitutions without constitutionalism is the catchphrase emanating from a write-up by my good friend and teacher, Professor H.W.O. Okoth Ogendo, late of Nyakach, most likely Kisumu County. He wrote this material a while ago, and everybody who imagines that he wants to be a constitutional lawyer or is a constitutional lawyer would have to identify with that. It's an international material. Relating this now to the Supreme Court of Kenya, which constitutionally is intended to be the master of the master interpreter of the Constitution, the impartial interpreter of the Constitution, the impartial practicator of the Constitution, in the sense that this interpretation must also be brought out in terms of, must be practical. Impartial, we are not even bargaining, but it must be impractical. It must be practical. The Supreme Court has done very, very, very well on this. It has brought itself out on so many aspects of our constitution in terms of opinions, in terms of case law, in terms of advisory opinions, case law, and so far we would not want to complain. Well, there may be issues which we may further have to debate, like the position of the Constitution, the position of the Supreme Court insofar as election petitions is concerned. But you look at that jurisprudence, it is apt, it is to the point. What we may require in the future is now compare notes with the outside world and see whether we can come in and bring out the small issues and come out clean. So far, so good for the Supreme Court.
Thank you, my Lord. I do not remember what my Lord said about the issue of writing joint or individual judgments in the court at your last interview. Maybe you could remind me if it was asked of you, and if it wasn't, could my Lord please tell us what your position would be on writing individual and or composite judgments?
Thank you, good Commissioner. This was not raised with me last time. I cannot remember. The 9 days ago, it was not raised with me. But my answer to this would be, I have looked at the decisions of the Supreme Court in both the majority decisions and the dissenting decisions in one or two cases. I have also read the concurring decisions of the Supreme Court. In the matter for Munya, the Chief Justice wrote a concurring decision. And in that concurring decision, he made a very, very sensible argument, jurisprudential arguments, that to the extent that the Supreme Court of Kenya is not the resolution insofar as election matters are concerned. These matters come when, in the last minute, as a last resort. Before that, we've passed such a long process. Firstly, starting with the people of Kenya. And the people of Kenya must be warned that it is their responsibility to make elections work effectively. The IEBC and other institutions of government which are charged with the responsibility of dealing with effective elections.
My Lord, let me redirect you to what we are looking for today.
Please do.
Thank you, my brother. First, it is individual versus the common judgment. That's the issue today. And I wanted you, I'm asking on behalf of the rest of us, to tell us which you favor so that I could ask the final question on the topic.
Yes, I favor a situation where every judge does their judgment.
Why, my Lord?
That enriches our respective thinkings, and we are open to society. We are accountable in the sense that this is an intellectual court. We all come out with our respective thinkings, and if society finds that society will find a way of merging it. The academia and everybody out there will find a way of merging it. But from the onset, let us all come out, because we are gifted in different manners. We have our riches. We have riches which every other person do not reach, and these are personalized. Therefore, the necessity to write individual judgments.
My Lord, it is true. I agree with you that we are gifted differently. We all have our different ways of writing. We could be saying the same thing, but one of us would say it more elegantly than another one would, etc. Does my Lord have any idea at all of a situation or situations when individual judgments would not be advisable?
I have not thought about that one, but I'm imagining that there may be areas like opinions, when the court is delivering its opinions on advisory opinions. This is an issue which is contemporary. This is an issue which is governmental, and this is an issue where the court should come out in unison and say, this is what we think, this is what we sell to Kenya, this is what we offer you as a court. In that kind of circumstances, a good commissioner. The issue of individual may not work very well.
Thank you, my Lord. Maybe we should discuss it at the next colloquium.
Please.
Because there must be instances where I imagine the court may want comfort in numbers. I can think of 3 instantly, but we will discuss that as the entire judiciary at a later date. My Lord, I wish you well.
Thank you.
Your Honor, now I would request the Honorable Judge Wasame to ask his questions.
Judge, I wish you well. I have no questions for you.
No. You must ask 1 or 2, please. You and me, make this place happy. Why would you want to back out?
I think we respect Judge Wasame's position, and I'll now move to Judge Majaja.
Please.
Thank you, Chair, my Lord. Like the court you sit in, one of the problems we have in adjudication is the problem of interlocutory applications. You agree with that?
No doubt.
Yes. Now, can you tell us briefly what are the kind of interlocutory applications that are provided for under the Supreme Court Act or rules or under the Constitution, the types of interlocutory applications?
Oh, in the Supreme Court, we'll have interlocutory applications which touch on a stay of execution. We'll also have interlocutory applications which touch on matters jurisdiction or lack of it. We'll have interlocutory applications which would come into the issue of Article 163(4), the issue of confirmation as to whether a matter is of general public importance or not. At that level, we would have interlocutory applications coming to court. The other area is the efficacy of 164(6), the issue of advisory opinions. Whether or not this falls into that category becomes an issue, and it would arise at that level.
And what of those interlocutory applications, maybe you would tell us which type does the Court of the Supreme Court and Court of Appeal have concurrent jurisdiction? Concurrent jurisdiction of the Supreme Court, Court of Appeal and Supreme Court.
One is a stay of execution. The other one is on a confirmation or otherwise on whether a matter is of general public importance. In those two, we would have that kind of a situation where the two courts get involved.
And for a certification application, is it necessary to have a decision of the Court of Appeal in the first instance, or you can go straight to the Supreme Court?
For certification, it is twofold. Certification would arise from the Court of Appeal, and if the Supreme Court feels that they would want to deal with it, they can deal with it on their own, either approve of it or disapprove of it. But again, you can go to the Supreme Court on first instance.
And lastly, on the issue of jurisdiction, under what circumstances would the court or Supreme Court entertain a third appeal? You understand what I mean by a third appeal? An appeal from a decision of the Magistrates Court.
That would be under very, very extraneous circumstances. And the jurisprudence of the Supreme Court is that if this has to arise, then this matter must have been litigated from day one, from the Magistrates Court to the High Court, to the Court of Appeal, and to the Supreme Court. That is the only circumstance where this would arise.
It would have been but all matters are litigated from the Magistrates Court. What makes it different, or what is the difference between that third appeal that would have been entertained, yes, and the one the court would say there is no jurisdiction? What is the difference, if there is? I'm not saying there is, but if there is.
So my understanding of this stratum is that we would move from the Magistrates Court to the Supreme Court in very exceptional circumstances.
Okay, and tell us those exceptional circumstances. Those are the ones we want to know.
Circumstances where there is a disagreement at the Court of Appeal, at the Magistrates Court, and this matter goes to the High Court. The parties again do not feel like they have had their share at the High Court, and they go to the Court of Appeal, all the way to the Supreme Court. And this again must come under the criteria of interpretation of the Constitution, interpretation of the Constitution, and the other aspect of the practice of the Constitution.
Okay.
Under those two sets or terms, this would arise. If any matter comes from down there all the way to this, on those two parameters, it would be a feasible matter for the Supreme Court.
So in election petitions concerning the county assemblies, can you tell us what the jurisprudence has been in relation to jurisdiction of the Supreme Court?
The jurisprudence has been that, firstly, the effectual jurisprudence of the Supreme Court in terms of in relation to its jurisprudence is that all these courts are competent and able to deal with the matters constitutional. So you cannot use that as a competence and ability as an excuse to go to the Supreme Court. So in the instant case, the Supreme Court has put it that matters which come from the Magistrates Court concerning the county assemblies must end at the High Court. Okay. That is our current jurisprudence.
Okay.
So, and
I'll leave it at that. Let's move to another area of law, which again is very important in the Supreme Court. One of the principles of devolution is that county governments shall have a reliable source of revenue to enable them govern and deliver services effectively. That one we agree. It's one of the principles.
Yes.
So how has the Supreme Court contributed to development of this principle, and probably will share with us one or two cases?
One, there was the advisory opinion on this subject, on the issue of revenue, where there was a stalemate between the National Assembly and the Senate on revenue allocation. the Supreme Court came out very, very clearly and brought out the formula or the solution to this by suggesting that they form a mediation committee, so that when we have disputes relating to revenue allocation, the committee, which comprises of members of the Senate and members of the National Assembly, would be able to thrash this out and come up with an amicable solution to the issue, or an outright solution to the issue. That is my understanding of the whole thing.
And what did the Supreme Court talk about the Commission on Revenue Allocation? What did it say about that Commission on Revenue Allocation in that particular advisory opinion, if it said anything?
The Supreme Court gave it supremacy over revenue allocation, but pegged that to sensibility and reasonableness, so that in the exercise of the powers of the Commission for Revenue Allocation, they would have to do it constitutionally. They would have to do it in accordance with the law.
So that is the decision of the Commission on Revenue Allocation binding or advisory?
The decision on the Commission on Revenue Allocation is binding, but can be challenged.
Okay. And finally, you are aware of the African Charter on Human and People's Rights?
Yes, I am.
And it is binding in Kenya?
It is.
Okay. You have been in the ELRC. What labor rights does the Charter protect? Maybe you can give us an exposition very briefly in terms of the labor rights under that Charter, because they are binding in Kenya.
The labor rights which are encompassed in the Charter are the right to work, the right to dignity at the workplace, the right to, pay for labor, the exchange between labor and capital. Basically, the Charter gives what we would even say is also, envisaged in Article 41 of the Constitution. Article 41 of the Constitution, and all the labor laws in this country, the Employment Act, and the other operationalizing labor laws of this country.
And are there any decisions of the Africa Commission that are relevant, or any instruments that are relevant under this treaty in explaining or expanding the right to work that you are aware of?
I am not aware of any.
Okay. Thank you very much, and thank you, Chair.
Thank you.
Thank you very much, Honorable Judge Majaja. Now I request Commissioner Marete to ask his questions. Commissioner.
Okay, thank you. Now, I only have two questions for you, my Lord. The first one, if you go to the Supreme Court, if you look at even the way the Act that governs the Supreme Court is designed, there is the order of seniority in terms of the appointment. Now, so effectively you will be judge number 7, the effect of which is that you'll be expected to do a little bit more than the others, even in terms of developing judgments where there's consensus, drafts, and all that. Now, when I look at your experience as a judge for the last now 9 years, you've mainly been involved in, employment and labor relations matters, so to speak. Now, Supreme Court, of course, has, the kind of matters that you deal with go beyond what you've been dealing with in the last 9 years. Not to underestimate what you've been undertaking, but just to recognize the wide purview of what you have to deal with in the Supreme Court and the attendant learning curve. Now, coming to the question, do you think that that would be a challenge in itself in terms of, hitting the ground running as soon as you are appointed, if we were to appoint you, considering your experience which has mainly been in one particular field of law?
Thank you for that question. We must appreciate that it will be limiting in the sense that for the last 13 to 9 years we've been in practice in one single line, and that has permeated the last 17 years of my practice. I caught up with labor at the Teacher Service Commission in 2003. To answer you is that we have our broadness and our personal abilities. Limiting as it may be, we are able to push in and do the learning. These interviews were declared about, we were shortlisted about 2 months ago or so. Before that, I mean, the Supreme Court was a stranger to us. We did not require any jurisprudence on the Supreme Court. As we speak now, I can bet that we are 60% through. That is why we are able to sit here and prove our case. So this becomes a learning process, and we have not been disapproved in terms of energy. We have not been disapproved in terms of ability to enter and take charge. It is not a big issue as such. We shall just get in, appreciate our position, take charge, and move on through education, through exposing ourselves, through consultation. But admittedly, that kind of practice where you've been in one line or one focus line and earlier on in another, I mean, that is a family law and succession earlier on, and now labor law can be limiting. That's a very precise and honest answer. But we can beat that outrightly because of our very nature, aggression and speed.
Okay. Now, my lord, the second and final question. I'm just thinking, as a commissioner, we've just appointed your sister as a chief justice from across the hill. Probably if you threw a stone, probably it would reach the homestay. I don't know, because I don't live there. Now, I'm just wondering, because the judges are wise men. In fact, they are wiser than us as a commissioner. The public, when they sit before a judge, they know a judge is a very wise person. Now, put yourself in our shoes as commissioners. You're a brilliant judge. There's no doubt you're answering questions well and all that, and you're competent by all means. But considering the realities that you have to deal with also as a commission, envisage a situation whereby tomorrow we say it's you, after we've just appointed your sister. How would you deal with that if you're in our shoes as a commissioner?
Thank you so much for that brilliant question. I expected that today, and if it skipped, I would have been very, very surprised. Let me give you my political theory on ethnicity. I don't use the other word. The word of TRIBE, I don't pronounce it because I think it is not realistic. It is just a figment of our poor relations. One, ethnicity has never been an issue, and I will demonstrate this. I went to Alliance High School in 1974. All other factors were constant. We would have jibes against A, B, C, and D, and E, and that was that. We left the place, no issues, no injuries, no nothing. In my time at the University of Nairobi, all other factors were constant. The only requisition for a student of the University of Nairobi was just reading and reading only. I'm even surprised that we did so poorly because we didn't have any other business apart from reading. Food was available, hosts of residence were available. If they were not available, we were taken to the hotels and we were given. All other factors were constant. No issues of ethnicity. To me, And having in mind that ethnicity has even become a discipline of study, my position has always been that it is not realistic. It's a creature of our own imagination, it's a creature of our own poor governance systems, and it is something we should be able to thrash out. People like you and me, who are in this country and have the wherewithal to thrash out these things, should sit and make a decision on this. It is not real. A good general walks to the battle with the best that he can at the forefront. This idea about diversity and what have you for Kenya, maybe for now, yes, because of our perverted governance systems in the past. We may have to deal with that one. But for the future, let us sharply rise up and think out of this, because it is not real. Such that good enough, you have my sister as the Chief Justice of the Republic of Kenya, and on the other age. If we use theory number one, I may not be eligible. I may not be the best of material. Everybody may make a lot of noise about it, and I would justify them. We know where we are coming from. But using theory number two, it would not make sense. The Supreme Court should have the creme de creme of this society. I belong there. So what, barring one or two other issues, what we should have in this sense is bringing out our best generals to the warfront and leading into battle, and we will sing into victory. To clarify or to polish my answer, that may be a big issue, and a big issue which I considered even before I came for this interview. But for now, I will leave it to the commissioners. But in the future, all the good brains in this place should come out and chat it out and tell Kenya and Africa that we are getting lost on nothingness. The issue is not ethnicity. Tackle the actual issue and deal with your matters, so that you and me can sit freely and ably and do what we can for Kenya, what we can for humankind, without any regard to our backgrounds, because those are not real to me. Thank you.
Okay. Thank you, my lord. It's a really tough one, but I wish you well.
Thank you. Let's see what happens in the course of the week or next.
Thank you very much, Your Honor. Honorable AG, Commissioner, it's your time.
Thank you very much, Honorable Chair. Good afternoon, Judge.
Good afternoon, sir.
You indicated earlier that you are in favor of writing individual judgments.
Yes, I did.
For the Supreme Court. Would you please tell us, have you identified any area or areas where you may give direction and leadership in terms of jurisprudence and its development if you were appointed as a Supreme Court judge?
I am a constitutional lawyer. That is an area I have studied and written on. It's an area which, is upmost in my interests. I may shyly also say that I'm an authority on the subject. It's my area of specialization. On this, I would offer leadership.
How have you demonstrated your expertise, my lord?
One, at the University of Nairobi in 2005 and 2006, when we went for our upper law degree. I specialized in constitutional law and government. It did not essentially carry that name, but that was my area of study, where we did matters touching on the constitution itself, constitutional comparative constitutional law, and other matters on democracy and the legal process, that kind of thing. In my write-up for my LLM thesis, titled Towards a New Constitutional Dispensation in Kenya, the Politics of the Constitution and the Constitution-Making Process, I tackled that subject very, very effectively under Professor H.W.O. Okoth-Ogendo, and it's called the topmost mark. I thank God for that, which is a demonstration that governance has always been my issue. I have vied for NIFI. I have vied to come to this commission because of my IQ and sensibilities insofar as the governance is concerned. We are saying that this is our area, and we own it cumulatively with everybody else who is in that discipline, and we can make a contribution in that line. I have also practiced in other areas, family law and succession, labor. We are able. Thank you.
Since your LLM and your political aspirations, have you at all demonstrated your expertise and legal scholarship in this area?
I have not had any further write-ups. I have pursued my career as it is.
Thank you, my lord. Let's move on to another aspect. As a judge of the Supreme Court, you would be asked to nominate or participate in the nomination of one of your colleagues, and you yourself would be eligible to become the representative of that court to the Judicial Service Commission, correct? Correct, my lord?
Yes, sir.
What attributes would you look for in the person to represent the court to the Judicial Service Commission?
One, ability. Firstly, let me say that at that level, any judge of the Supreme Court is capable and competent of appearing before, representing the court in this commission. But specifically, if that was very, very necessary that we nominate one and get him to the Supreme Court, we would look for ability and agility, flexibility, the team power in the candidates, issues on HR, because HR comprises a very, very critical part of the functions of the Judicial Service Commission. So we'll be looking for a leader who is all round, a leader who is able, not one among his equals, but one who would be able to do it better than any of the other 6 members of the Supreme Court.
And where would collegiality play a role in your determination of who to send?
That is where I started. I said that from day one, it could also, and this is a problem we also have in our small court, the Employment and Labor Relations Court. We are 12. We've gone to elections twice, which would be easier in the circumstances, unless a member of the court opts out and says that I'm not interested, like I have insofar as my court is concerned. I've always said that I don't want to be principal judge. Let it go to anybody else, but not myself. On the same footing, we could have a rota, seniority or juniority, whichever is earlier, so that everybody is able to, because competencies, abilities. So the other issue is choice. Do I want to be there or don't I want to be there? So that in that rota, everybody takes their fair share. When the time reaches, you just get there automatically. We don't have to go to elections. I mean, elections, we know them in this country. I mean, where do they take us? I remember I got 3 votes when I applied to join this commission. 3 out of 4 or 2. That is what elections are.
Thank you. Sorry,
do I do the finesse of my answer? Collegiality would also come in several senses of the word. Assuming my approach, my formulas, my everything doesn't work, we'd have to sit as a court and agree that this is a big issue, yes, representation in the Judicial Service Commission, yes, but it's not a matter of life or death. So how do we go about getting one of us to be a member of to represent us at the Judicial Service Commission? And through, involvement, through consensus, in a very friendly manner, get one of us to come to the Supreme Court, to come to the JESC, because any other method can bring a friction. And you remember, we are only 7 or at the best 9 in the future, and that can be extremely dangerous. So collegiality is utmost. It is a primary. It is cardinal. It is very, very important. We must move around with each other, cajole each other, buy each other tea if we can, or any other drinks, weird or not weird, and come to a conclusion, to a consensus as to whom we take to the Judicial Service Commission.
Thank you very much, my Lord, for answering those questions.
Please, thank you. It's been a pleasure.
Honourable Chair, nothing else from me. Thank you.
Thank you very much, Honourable AG. It's now the time for Commissioner Gishohi to ask his questions.
Thank you, Chair. Judge, good afternoon.
Good afternoon, sir.
I want us to look at another angle. In this case, I want you to focus to you as a state officer, because as a judge of Supreme Court, you are also a state officer, and you are bound by Article 10 of the Constitution. When you look at Article 10 of the Constitution, as a state officer, one of the principles of governance, one of the principles and the values of governance is sustainable development. Sustainable development. What is the role of judiciary in your view in enhancing this principle of governance under Article 10?
Thank you. Many of us in the judiciary, and particularly judicial officers, mistakenly believe that we sit here to write judgments, and you carry your files and do blah blah, and in that imagination forget that you're in governance, and at the center of it, our decisions are determinants to governance patterns in this country. You're either directing this way or the other. This is the way we ought to go, this is the way we ought not to go. And that way, we are in the center of governance. And we are in control of the governance patterns of this country. That is why we are an arm of government, like the other two. So in this regard, judges should always have appreciate their positions as a transformative leaders.
Appreciate, that is one. 2.
Number 2, you must make decisions which are pro-development and pro-Kenya. You are not going to allow situations that you are making decisions that stumble Kenya, unless that is really the spirit of the law, which would never be. No law would come out with a situation that stumbles us in our development patterns.
Okay, from that basis, Honorable Judge,
please,
I want you to look at our medium-term programs, MTF, and I want to look at the 4 key agendas that the government is in the process of implementing in the country as we sit here this afternoon. Would you share with the Commission those 4 programs of agendas as we know it, the government is currently undertaking? 4 agendas. Key agendas.
One is provision of housing. The other one is medical services to the Kenyan citizenry. The next one would be sustenance of a rule of law kind of a situation where we are able to run ourselves, our governance patterns in appropriate manners in accordance with the constitution and the laws of this land. And what is the last one? It is evading me. Given a little more time, which time we don't have, I'll be able to pick it.
Okay.
But the politician is me, is failing me.
Okay.
Thank you.
Let's move on, Honorable Judge. And I want us to look at the public finance. There's a judge of the Supreme Court. Definitely you'll be having some resources with him. And I've also seen that some of your duties in your current station is your managing staff and also doing work on administration. Under the Article 2, Chapter 12 of the Constitution, there are 4 key general principles on management of public finance, which is very, very important for any public officer. Would you share with us 2 of those principles?
One is sustainability. In issues of public finance, there must be this must be sustainable in the sense that you are not dealing with public finance without bearing in mind that this must be towards it must be pro-Kenya. It must be towards development of the aspirations of the people of Kenya.
Okay.
The other one is accountability. At all times when you deal with the issues of finance, accountability is very, very critical, so that we use our resources to the best of our ability in the best senses and account for the same.
Okay. I remember last time you came here, you spoke about this issue. You can also repeat it if you want to. How do we make sure that we fight corruption or wastage of public funds as a state officer? 2 ways that we make sure that we fight corruption and wastage of public funds.
The stakeholders, who are the stakeholders? The judiciary sits at one corner. Auditor General sits at another corner. The other government agencies also sit in a different corner. There must be coordination between these, so that we are able to appreciate a situation that we are able to curb EACC, the Anti-Corruption Commission. We are able to curb corruption, not even curb, eradicate entirely, and it is doable. In this sense, if everybody stood fast and firm and said that I'll play my role and play it accordingly, in the next 2 weeks we'll have reduced this by 40%. In the next 2 months we'll be hitting 70. In the next 2 years it will be not.
Okay. I've seen from your later appearance, you are saying that one of your duties, principal duties and responsibility, is providing leadership with a view to enhancing service delivery. That's one of your duties in your station. Would you share with the Commission how you enhance service delivery in your court? What targets do you set? What tools do you normally do to ensure that you enhance service delivery?
One, it is the first one is accommodation. Like I said last time, you get your staff right, and when you have your staff right, now you can work on everything else. You must be able to operate with an accommodated staff at parity, where you and everybody else are equal and only differentiated by designation. Number 2, you educate these people on the need. You see, in everything we do, we don't look at the judiciary. We look at the broader picture, Kenya. It is the Kenyan citizenry who benefit from everything that we do in our respective areas of work as a public servants, even in the private sector.
Good training.
So you train them and you teach them. You even go a notch higher and educate them on the finesse of what is expected of them and why it is expected of them and for what benefit it would be to society.
The last one?
The last one is, you must implement policies. Policies which now actuate what is in your mind. After acquiring one and two, you must bring in policies. You must bring in finances to accommodate finances and the infrastructure to accommodate that.
Finally, Madam Chair, Honorable Judge, can you speak a little bit about reward and sanctions as far as managing the staff is concerned? Reward and sanctions on those two principles. Share with us your thoughts on reward and sanctions.
Yes, it's a HR tool. HRM tool is a HRM tool which is which should be recognized and appreciated and practiced. One, we have idlers, people who have all the energy and take all the tea and buns, but are not productive. They just take their tea and take their buns and idle around. It is 5 o'clock and they walk home. And further take so many other things and come back the following morning. That is where the issue of sanctions comes in.
So what do you do with them?
You deal with them, you warn them. Firstly, you start by talking to them. You counsel them. You tell them that here there are two things. One, there is a return for capital. We are paying you, you must give us A, B, C, and D, and that is your contract. So if you are not able to work on that, we may be at war sooner or later. So you start by counsel. You go to warning. You go to, evaluation of the results. And if the worst comes to the worst, you may have to now come to the contract and say, now, we agreed on ABC. You are producing X, Y, Z, or nothing. This is what is going to happen. That is going called a departure in employment law. So the other one is a reward.
Yes.
Those who do well and exceptionally well, like myself, the JESC should look for ways and means of decking us over Christmas, over Easter, and you deal with us nicely, because we are not only setting a good example to the others, we are not only pulling them up, we are telling everybody that it is doable. You must not necessarily be an idler.
Thank you, Judge.
We have the acumen to do it.
Thank you, Judge.
Thank you, sir.
Your Honor, I think the Commission has had that request from you. Commissioner Koskei, please go ahead.
Thank you, Chair. Good afternoon, Judge.
Good afternoon, sir.
Supreme Court Judge and resource mobilization. You are now walking into Supreme Court as a judge, and judiciary generally have limited resources. However much the government wants to allocate, there are a lot of competing needs in the country, and therefore many institutions look out to development partners, their international networks, to see how they can raise funds to support some activities in their institutions. Would you tell us how, as a Supreme Court judge, will you help the head of judiciary to mobilize resources so that the services that judiciary renders to the public are done efficiently?
To be honest, this is my weakest area. I do not believe in begging whatsoever. However, we have our conditionalities and our situations here. Donor funding has moved us this far, not only as a judiciary, but also as a nation. I may not be very good at that, but we have what we call delegation. I may have the ideas. Don't set me to the forefront, because that may not be very, very good for me. But we have other people who can do this. I may have my tentacles upright and identify areas where we can seek funds, and we know them. So it is not personal. In as much as I may not be a beggar or may love begging, I know where we can go, and we can send other able-bodied people and able-personed people to do this. In the absence of that, if we didn't have them here, and I believe we have so many of them, we can hire these fundraisers, and they will be able to do that for us.
Thank you, Judge. Let us now go to performance. There has been an effort to introduce performance management in judiciary, and there has been an equal measure of resistance or perceived resistance, especially from judicial officers, where they say you can't measure, you can't dictate to how or when should I, finalize my activity, whether it's a case or whatever you are handling. To the extent now that it is very difficult to make the institution as efficient as expected, and more difficult to measure. The metrics that are always used for institutions in as far as service delivery is concerned becomes a bit difficult. What are your thoughts on introduction of performance management in judiciary, and how can we mainstream and entrench it so that each and every worker or employee of judiciary embraces it for the betterment of service delivery?
Thank you for that question. Let me start by saying that performance management is a part of us today. It has been there for the last 3 or 4 years or slightly more. And the issue of resistance was the old day thinking or mentality of judicial officers. Not anymore. I have not seen any resistance from anybody or from any quarter, at least not any which is noticeable or physical, which you can be able to see. We are all in it, and those of us who are well-intended are fully in it. We may have small circles of resistance, like you are saying, or unwillingness, reluctance to embrace performance management. But to those, let them be warned. I come from the labor and employment and labor relations circles. I'm an expert in that area. A contract becomes a contract. When you come here as a judicial officer or by any other definition, as a worker for the judiciary, you don't come to do your things. You don't come to dictate terms. You come to do that which your employer requires of you. And if that is part of it, you have no choices. Number 2, we are just being archaic. Archaic in the sense that we resist measurements of what we do, then we must be clandestine or something to that extent. Everybody from day one, when you used to go and weed other people's chambers, you are given a portion. That is for 10 cents, that one is for 50 cents, and you weed the whole piece, and nicely it is evaluated, and you are paid your 10 cents, not 10 bob. 10 bob was for a whole month in our time, or your 50 cents. And that is where we are. That is what every worker, every society which wants to make a sense of work must embrace. Those small circles of resistance, one must be crushed by any other means, not physically, of course. We must talk them out of it. Number 2, we must be able to realize worth. We pay you, give us the worth of that pay. It's a matter of exchange. That is why it is a contract. So we cannot negotiate that, good Commissioner. Everybody must be measured. That way we'll be able to do our best, optimize, clear backlog, make Kenya free, liberate our economy, and liberate everybody else. I mean, we have people who walk in court every other day because I don't want to be measured. Nothing.
Thank you. My final question is, I've gone through your CV and I saw Kirigi attended primary school. You founded Kirigi and you stated that it was community service. But I see that you saw some opportunity to do business. Is it community service really?
Good enough, good enough, good
you got a
enough.
chance to do business by establishing a school in your county?
Thank you. That is a very warm question. Kirigi Tented Primary School starts on 6 acres, which belongs to my family. The lower side of the river Rogoti is a forest, which I've done for humankind. Everlasting forest, equivalent of Mount Kenya forest, which is about 1.5 kilometers from Kirigi Tented Primary School. Kirigi Tented Primary School was my idea of return to society. From day one. I mean, I never went to school on my own. I mean, my dad and his good friends would contribute or sell a cow or two and take me to school. In this status and being so endowed, I thought the best thing was to advance education in that place so that everybody is able to get a chance to get to Alliance High School or any other golden high school in this country as of right, like I did. And that's how I started the Kirigi Tented Primary School. I've run through Kirigi Tented Primary School with lots of difficulty because of the confusion of politics and a few other things. But we stand. Kirigi Tented Primary School is there. We charge some little fees. We pay the balances from what you pay me. And I am very, very comfortable. Kirigi Tented Primary School was born out of an idea to do all Kajiado University I only went to that level when I realized that you cannot start up there when the young boys and girls of Kirigi, where I live, are not even able to get quality education. That is a private partnership where my family or our family has decided to invest in society. Principally, I believe in that. I am doing it, and more often than not, you find kids there who have been promised that between where they are to infinity, PhD and beyond, my family or our family will be able to meet their expenses, walk them throughout the school if we can afford. And if we can't afford, we may be able to, through our interactions with everybody else, be able to get them that far. We are trying to enhance a society, we are trying to enhance Kenya, we are trying to enhance humankind at our expense.
Thank you.
Thank you.
Thank you. Thank you, Judge. Thank you, Chair.
Thank you very much, Commissioner Koskei. Commissioner Orode, please go ahead, it's your turn.
Good afternoon, Judge.
Good afternoon. How are you?
Fine, thank you.
We thank God.
Do you believe that we have instances of abuse of judicial power? And if you do, please tell me how the Constitution seeks to check abuse of judicial power.
Yes, we have instances of abuse of judicial power. Thank God, post 2012, this has come to very reduced levels. We do. How does the Constitution now come in to check on this? The Constitution is very, very clear that judicial authority belongs to the people of Kenya, and we are just, agencies for Kenya in this kind of exercise. All powers. Let's start with sovereignty. Sovereignty belongs to the people of Kenya. Collectively. So every of us who is a state officer or who works in the public sector is just an agency for the people of Kenya. You are on borrowed authority. So you cannot go there and imagine that you are in charge, you are the ruler. The ruler mentality has been overthrown by the Constitution of Kenya 2010, and any other constitutions generally don't accommodate that kind of thing unless they are archaic in their thinking. So what we have today is a situation where at all times we are warned that it is not ourselves as the judicial officers. It is not ourselves as workers of the judiciary. It is Kenya and no more.
That is true, Judge. That is the situation. We derive our judicial power from the people. But what mechanisms has the Constitution put in place to ensure that that power is not abused?
The Constitution of Kenya has put in Article 10. What is Article 10 all about? Article 10 is about the imperatives of a state officer, a good governance, and these are all elaborated in that article. The issue of equality, the issue of gender, looking at gender, affirmative action, the issue of regional equity, the issue of equity itself, equality. Those are attributes which the Constitution has provided for us to deal with this. There's the article on public service, 232. It gives guidelines as to what a public servant ought to do and not to do. Article 73 on leadership and integrity. It defines, it tells us all there is. When you are a leader, like in your position, you are in leadership. I am in leadership. We don't do this on our whims. We are guided, we are controlled, and we are mandated to do that or take off, walk home. Precisely that.
And so also Article 159.
Oh yes, 159, the one which is on judicial authority and the way it ought to be exercised, the issue of technicalities, the issue of alternative justice systems, the issue of fairness, the issue of impartiality, et al.
Thank you.
We are clearly guided. We cannot run away unless you want to offend the Constitution, and if you do, there are consequences. We are in business.
Thank you. Judge, could you please explain to us the mischief rule of statutory interpretation?
Statutory interpretation, if I remember Professor H.W. Kothagod, then he was a doctor in my first year. It depends on two criteria. One is the plain words of the write-up in the statute. Two is the marginal notes. Mischief comes in this, the intention of Parliament. It is part of the whole thing. Number 3 of element number 3 of a statutory interpretation. But this is where the mischief comes in, because every other time I find you in the streets of Kinangop, you'll be talking about this was the intention of Parliament. This is the spirit of it. etc. Do I repeat? etc. That is where the mischief comes in, and that is where we must be checkered and checked, so that we don't abuse statutory interpretation by imputing what Parliament may have imagined or thought, etc. When that arises, and you want to be very, very clear, you go to the Hansard, the debate on that statute. You get answers. If you are not able to get answers, as a judicial officer, you must be cautious, you must be guarded, you must warn yourself that you are treading dangerously. Minus that, it will be chaos all over. Everybody will be coming up with these intentions or imaginations of what Parliament intended. Did I get it right?
I won't say that. I won't give you an answer to that.
Don't answer.
But I want to ask you,
Yes.
then what is the golden rule of interpretation?
The golden rule should be the reverse of that. The plain words of a statute. Those ones will give you the meaning. If those don't give you the meaning, that is the golden rule. The literal reading of statute. If that doesn't work, you go to the marginal notes.
Okay, thank you, Judge. My other question concerns surrogacy. In your view, who has parental rights and responsibility in a surrogacy agreement or surrogacy arrangement?
That is where tricks and trickery comes in. A good commissioner of the JESC, but being lawyers, we must answer it in the strict sense of the law. Here we have a contract which involves two people, the surrogate mother and the surrogate himself or herself. So who has parental rights at the end of the day? The law and the reality may be different. And this is where we come in and have to deal with the delicate state of affairs in the relationship. Because the law provides that in this contract, the one who has rights to the child at birth is the surrogate, not the surrogate mother. But we are also getting to
Judge, so that I understand you clearly, when you say the surrogate and the surrogate mother, who are you referring to?
The surrogate mother is the woman who is used to, conceive and bear the child. To me, the surrogate is the contractor.
The one who carries the baby?
No. Good enough, yes. The contractor is the one now who, in reality, is supposed to own the baby when it is born.
Mm-hmm.
So here we are saying the law favors the person who contracted the surrogate mother to bear the kid. But the reality of the matter and the actual, human rights situation comes in this sense that I have contracted to bear, to conceive and bear your baby. I have it, and then I start claiming rights in it. So who has a superior right in the circumstances? This is a constitutional issue. It's a matter of law. And if you ask me, I would say ultimately, at the close of the day, the mother is the one who is, the mother has a bigger stake in the entire contract, in the entire matter. We have had a breach of contract in actual contract law. This will be a breach, but ultimately, insofar as constitutionalism is concerned and human rights, the mother would be more entitled to the baby than the contracting surrogate person.
In this case, by mother, you mean the one who
who conceives and bears the kid as superior rights to me than any other person.
Okay, thank you. So in our current dispensation, I know we do not have a legal framework to govern that, but there are cases that have been determined by our courts. In our current dispensation, how does I prefer to call her the prospective mother, the one who asked another to bear the child, to carry and bear the child on her behalf. How does she acquire parental responsibility, assuming there is no quarrel? How does she acquire parental responsibility and rights over the child that is born in a surrogacy arrangement?
This is by way of adoption.
Thank you.
They have to take the kid and walk through that process and get it to themselves legally and in law.
Thank you. My last question will be, can a judge participate in a tender for supply of goods and services to the judiciary or the Judicial Service Commission?
Not a judge only. None of us who work for the Judicial Service Commission or work in the judiciary supposed to have any commercial relationships with either the judiciary or the Judicial Service Commission. This would amount to, in the first place, it would be bad manners, like my good friend Elisha Ongaya would like to put it. Number two, it would be, besides bad manners, it would be outrightly immoral. And thirdly, it would create a conflict of interest. In fact, I would not like to imagine that that would happen, but if it does, it should be, ostracized to the end of the world.
And do you think there are exceptions to that rule?
I have not found any. I've not been in a procurement. I have not found any. But I would think of a situation where you have expertise in an area which is alien from your employment contract. And this cannot be achieved in any other circle. That's the time, and when all other factors are constant and there is a declaration of it is open and transparent, maybe your services, like if we wanted to do a international competition on chess, and we have a judicial officer who is a chess player of international excellence, and this is not his part of the game. It's not his cup of tea.
If I may just interject, the question was if there is an exception to the general rule that you cannot participate in a tender to offer goods or services to the judiciary or the Judicial Service Commission. Are there exceptions to that rule?
I am not aware of any, but they can be there in situations where the matter comes out very, very openly, transparent, and where all parties and everybody else, including the Kenyan public, is involved and warned of what is happening and approves of it. Because the judiciary is the property of the Kenyan public. The Kenyan public must participate in it, people's participation. So in such delicate circumstances, which should be rare, there must be movement of every other stakeholder, and there must be absolute transparency.
Okay, thank you, Judge. My last question, my final question. Not everyone is good at everything. What do you consider to be your weakness, and what have you done to remedy it?
Now that's a difficult question. My weaknesses, they are rare. Let me a little more time to think about it. I'm not, in relation to what I do in the judiciary, maybe not. In relation to, myself, home. Let's get home again and get our short-tempered nature as people from those sides of the mountain. I carry that also, but it is just instant, and it goes away almost instantly. We have realized that you cannot fight it out and win in some of these matters. Matters creation, matters relation, matters which have to involve, because you cannot go it alone. So when such situations arise, and we've taught ourselves over time. It was poor in primary school. We went through high school. We are now grown-ups. We are getting into, into eldership, and we've temperated this so that we are able to cope even with the worst of situations without over-employing or over-emphasizing such a disability.
Thank you very,
That's the
very
only
much,
one I
Judge.
could remember very clearly.
Thank you for your honesty. That's all that I have for you. I want to just mention, I think the chair already mentioned that we got the documents that you updated. Thank you for that. They'll be considered by the commission. I wish you well.
Thank you so
Chair.
much.
Thank you very much, Commissioner Rade. Honorable Judge, just a follow-up from what Honorable Rade was asking about the contractor, back to the surrogate mother, about the contractor of the service and the surrogate mother. And you said that at the end of the day, the surrogate mother has the right. So my question is, Judge, if there's a contract, does that mean that contract then is not binding, or what is your view?
Contracts, those of us who have reminisced through the law of contract are not proof. There may come circumstances which make it impossible to effect the contract. There is also what we call a breach of contract, and in a breach of contract, the remedy is restitution or compensation for what you've lost in the game. In the instant case, we are not looking at the contract. The contract is not the primary issue. What is the primary issue is the human rights issue. The mother of the baby vis-a-vis the contracting parent. So if you look at that one and you get that it is not feasible, if the mother decides to make an about time, it will not be, total denial, it will just be breach of contract, and it's a compensatory. The other party can get what they ought to get insofar as the breach is concerned, and we cure the bigger issue, which is the human rights of the baby and the surrogate mother.
Okay, thank you very much, Judge. And we now come to the end of this interview. Your Honor, we want to thank you very much on behalf of the commissioners for coming for the second time and talking to us. Do you have anything you want to tell us, Your Honor?
Firstly, the card is here. Should you choose to look at it, it is available. Secondly, we would wish to thank you and thank you so much for awarding us another opportunity to come and have our feel of the two very principal vacancies available in the judiciary. Now it is one. And for that, we thank you. We thank you for your cordiality also, the openness, the heartiness. I only missed the bit of my good friend. He want to deny me at the hour of need, but we've always been friends. I should have been there. Next time we come to the commission to the commission for this kind of exercise, let's have you good, my good friend, Commissioner Wasame. Give me an opportunity also to thank those who have been with us in this matter, particularly my referees. They laded the references to me. That was very, very kind and very accurate. I would thank them. My global fans, fare thee well. Another moment will come and we shall be there. Thank you so much, good commissioners. Thank you so much, Chair of the Commission. Thank you, and may God gladly and mightily bless you all. Bless the judiciary of the Republic of Kenya. Start with the Republic of Kenya. Oh, God's grace and blessings. The judiciary of the Republic of Kenya. Every other grace and blessings. The Judicial Service Commission. All the time. What we don't remember when we come here is that we shall always need the judiciary. We shall need the JESC. And we must always be very, very careful how we address ourselves in circumstances like these ones. Thank you so much. It's been a great honor. Welcome.
Thank you, Judge. And once again, we have learned a lot from you too. And we have noted for record that the disability card now is only vision. And we want to thank you for correcting that error, Your Honor. So thank you very much, commissioners. And you can give back the...